Here, tippy type. Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery Today's Doug Austin called Ethics and Explainability of AI Algorithms in Legal Use Cases with our faculty experts, of course, Doug Austin, Tom O'Connor, Dr. Maura Grossman, and myself. We welcome your questions and feedback in the console. This webinar will be recorded and available for your replay at your convenience, as are all of our EDRM webinars. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here with us today. What do we have in the line of resources for our listeners, Kaylee?
Well, it'd be good if I'd unmute, wouldn't it?
It certainly would.
If you would take a look at the paperclip on your console to the right, we have stay up to date with your eDiscovery news and case law by subscribing to Doug Austin's eDiscovery Today blog. You'll see a link there. And when you subscribe, you'll also have access to his most recent State of the Industry report results. It's phenomenal. So take a minute and subscribe and download the report. Also, learn more about Dr. Maura R. Grossman here. She has some fascinating papers and information and is definitely a thought leader worth following. And then last, check out Tom O'Connor's Spicy Techno Gumbo blog here and subscribe. And then up next on the EDRM webinar channel tomorrow, are humans underrated in eDiscovery? And you'll see it's going to be a great discussion. And there's a registration link for that. Back to you, Mary.
Oh, thanks, Kaylee. And for our listeners, you can download a certificate of attendance from the console after the webinar for continuing ed requirements. And our faculty, Doug Austin, our moderator today, editor of our EDRM partner, eDiscovery Today, is an established eDiscovery thought leader with over 30 years experience, providing eDiscovery best practices, legal technology consulting, and technical project management services to many commercial and governmental clients. Doug has published a daily blog since 2010. He writes articles, white papers, and he's received the J.D. Supra Reader's Choice Award 3 times. And Tom O'Connor, hailing from the great city of New Orleans, for 3 decades, he's stewarded the Gulf Coast Legal Technology Center. He's a sought-out consultant on some of the largest cases, including the BP oil spill and more recently the opioids. He's written a book recently called eDiscovery for the Rest of Us, and you can access that on the gulfltc.org site and 50% off with JHU22. And Dr. Maura R. Grossman, she's a research professor in the School of Computer Science at the University of Waterloo, teaches at Osgoode Hall Law School and the Vector Institute, all in Ontario, Canada. And she's an eDiscovery attorney and consultant in my hometown of Buffalo, New York. Previously, she was of counsel at Wachtell Lipton, where for 17 years she represented Fortune 100 companies and major financial institutions in civil litigation and white-collar criminal and regulatory investigations. Chambers calls her a superstar among superstars in technology-assisted review. We just call her the star of TAR. And we are glad to have all of you. And over to you, Doug.
Thanks, Mary. Great to be here and welcome everybody. I feel like we're trying to cram 5 hours worth of information into 1 hour, but we're going to do our best. And we have a lot to discuss related to the ethics and explainability of AI. And honestly, each of these could be a webinar in itself. And we'll start by discussing AI legal use cases, of which there are more than you might think. We'll also discuss the current level of acceptance of AI in the legal community. A big part of today's discussion will center around the challenge of bias and considerations for access to justice in criminal law. We'll also briefly touch on privacy considerations and applicable ABA model rules and resolutions. And we'll discuss some questions you should ask vendors about their AI products to make an informed and educated selection. And of course, we're going to try to leave some time for questions as well, and we encourage them along the way. We'll try to address them as we can. And it hasn't been mentioned up to this point, but we will send a copy of the slides out after the presentation, which has numerous links to resources you want to check out. So keep that in mind as well. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Even a chatbot can understand that. And so with that in mind, let's get started by discussing some AI use cases. Of course, the most well-known AI and machine learning use case for eDiscovery professionals is technology-assisted review, also known as predictive coding, which has been advocated for and court-approved for over a decade. More on that in the next slide. But there's several other use cases that exist for AI and machine learning as well. That includes everything from classification of personal and confidential data to records retention and categorization to even cybersecurity threat detection and compliance with regulations. We're even seeing bots on legal websites, and AI is writing research and briefs, and the list goes on. In fact, this morning, Tom sent me an article about a college student who created an app that can tell whether AI wrote an essay. So the use cases just continue to multiply. So Tom, I'll start with one of these use cases. How is AI and machine learning being leveraged from a perspective of identifying and removing personally identifiable information?
Well, this is an area that just really lends itself well to AI because of the standardized format of many types of PII. Of course, social security numbers, driver's license numbers, date of birth, in many cases, policy numbers on insurance companies. You know, they're all, if not a standardized format nationwide, certainly in specific cases, you can come up with formats that are standardized and tailor the search for them. So there are, in fact, dozens of search and redact PII tools out there. It's one of the oldest uses of this type of technology. In fact, the very first project my son Seamus, who now works for Joy Morrow at PAR, first project he ever did was a big case we had with the federal defenders years ago, where we were doing exactly that. We were searching through data to make sure that PII had been removed from material before it was given to the defendants who were incarcerated at the time. And we were able to write scripts for the products that we were using to just go and do that. So highly available, very widespread, very effective too, which is a point we'll talk about later.
Sure, and a very important use case, no doubt about it.
Yeah.
So Mary, another one that maybe people don't think about as much is cybersecurity threat detection, and that's another area where we're seeing the application of AI and machine learning. So how is it being applied there?
Well, if we think about cybersecurity in the way that legal people approached the volumes and volumes of documents and data. I mean, at first humans were looking through logs. Cybersecurity professionals were eyeballing the logs. And later, just like with attorneys, you could do things like hard search terms, I'll call them, where you could search for specific strings and things like that. And then, of course, fuzzy search, and then near dupe, and all the different technologies that we've introduced ourselves to, they've introduced themselves to earlier. But from use case perspective, knowing when to distribute a security update, penetration tests are now being driven by AI and machine learning, monitoring devices, and mostly summarizing and making recommendations and actions, identifying insider threats, looking out on the net, predicting where the bad neighborhoods are, to keep users safe while browsing. And the one that really just jazzes me is detecting malware in encrypted traffic. How fun is that?
That's a really good one. Yeah, it's really impressive, some of the things they can do. And so it's important to note, there's a lot of great use cases. These are some examples here. And as we proceed to talk about some of the challenges with AI, there is a lot of good that AI is providing to the legal community. So absolutely. Now let's discuss where acceptance of AI and machine learning stands within legal. And we'll start with the result from the predictive coding question from the 2023 State of the Industry report that Kaylee mentioned that was released last week by eDiscovery today and sponsored by EDRM. And shameless plug warning, you can learn how to get the full report for free by clicking on the link at the bottom of the slide there. Regardless, when asked what percentage of their cases use predictive coding, only 29.2% of respondents in this year's survey said they use predictive coding technologies and approaches in all or most of their cases. And less than half of the respondents, 42.1%, uses it at least half the time. Conversely, more than a third, 35.4% of respondents, use it in very few or none of their cases. So not exactly worldwide acceptance yet, even from people who care enough about eDiscovery to complete an eDiscovery survey. So Maura, it's been almost 12 years since you and Gordon Cormack published your Richmond Journal of Law and Technology article about TAR and how it can be more effective and efficient than manual review, but less than a third of respondents here said they use it most of the time. So why do you think that more legal professionals aren't embracing TAR?
Well, the whole thing surprised me. I thought in 2012 or 2011, when we published the paper, that it would really be a matter of minutes before sort of everybody drank the Kool-Aid. And boy, was I wrong about that. I think the reasons have changed over time. I think early on, the incentives of using this technology were not aligned with sort of the billable hours model. So it was initially a hard sell to law firms and legal service providers. I think people realized later on that that's not a great way to maintain or get new clients. But I think also early on, the costs were relatively high. And because there was this upfront extra cost to use the technology, but you didn't see the benefit until much further downstream, it was harder to make that sell. I think, again, after people have used it a few times and they see the cost savings, it's an easier discussion to have. I think also the somewhat early approaches, and still some of the approaches now were fairly complex to do, and you needed experts either to help you run the process, or in some of the early TAR tools, it was thought that you needed an expert to train the system, and that made it less appealing. I think now what drives more of the reluctance to use is disagreements over what needs to be disclosed, disagreements over what is the proper way to validate. And I think there is distrust, and people want to avoid disputes. So sometimes it's just easier to go back to I guess, the horse and buggy than it is to engage in either learning the statistics or having that fight with an opposing counsel.
Indeed, and certainly we'll touch on that a little bit more here in a couple of slides. So thanks, Maura. That's yeah, there are a lot of challenges there, but I mean, certainly, we're seeing the adoption of predictive coding growing, right? Well, this is actually the third year of the State of the Industry report. If I can get there we go. All right, there we go. Unfortunately, the highest numbers of predictive coding adoption was the first survey 2 years ago. Last year, the use of predictive coding actually regressed from the 2021 survey before partially rebounding this year, meaning that growth and adoption has been stagnant at best, at least based on the survey results. at least one bright spot this year is that the numbers did go up, and it was a broader survey population than ever, which is somewhat encouraging. So, Mary, do you think these numbers are reflective of the percentage of the actual use of TAR throughout the litigation community? And if not, do you think they're more optimistic or pessimistic than the reality?
Well, I'm going to go with the glass half full, man. If you take a look at the green on your chart, on the slide, you can see that the category none, the people who are not using it at all, has gone down, even with the other numbers of all or most aren't going in the right way. I think more people are using it, so I'm highly optimistic.
Okay, well, that's a great point. Even I hadn't really fully embraced there. So very interesting. So Tom, Maura brought up the idea of law firms and the incentivization on the billable hour model. Do you think that today most law firms are incentivized enough to consider a shift to TAR, considering that long-term reliance on the billable hour model, or do you think that's still an issue?
So, Doug, are you saying that you think that increased efficiencies, faster, speedier use of your staff, and an enhanced compliance with FRC P1 and its mandate to handle matters in a manner that's just, speedy, and inexpensive? You think that's not an incentive enough for people to use technology? You think they're getting hung up on the billable hour? Wow.
I'm just
shocked.
asking a question here.
I'm shocked. I'm gonna continue something first that Maura said. People would rather use the horse and buggy than learn statistics. Unfortunately, I think that's a huge factor. None of us. Well, I'm sorry. Maura is probably the clear exception to this. Most of us didn't go to law school because we were math whizzes, or in fact had any interest in math. In fact, tried to avoid math at all costs. And so I think that's a factor. The fact that this is a technical issue is a real problem. I think that Mary's point, though, I want to kind of take that one step further about that number of non-users hasn't really changed. You know what's changed is the number of small firms and small cases who are faced with the use of, let's say they're faced with increased amounts of ESI. Mm-hmm. And I think those people are, if you will, the anchor on usage for reasons primarily of cost, but also of easily available technology that they can use in small cases. I think if you did a survey that was only focused on the AmLaw 50 or even the AmLaw 100 and maybe GCs, I think those numbers would be vastly different. I think that percentage of people, the usage is going up, has been going up steadily ever since Maura's article to make her point.
Mm-hmm. Yeah, I absolutely agree, Tom, and great point. And a comment from the audience: reluctance to change and technophobia, which you mentioned, Tom, also a key issue in adoption, and I couldn't agree more with that too. So, yep. Absolutely. So, let's talk about barriers to acceptance here for a moment. Back in 2021, Maura and Gordon Cormack published a paper in the Ohio State Technology Law Journal titled The eDiscovery Medicine Show. In it, Maura and Gordon invite an open and honest dialogue regarding the need for truth in science and eDiscovery, drawing a parallel between how eDiscovery professionals approach culling a VSI and the medicine shows of the early 1900s, where unscrupulous purveyors of magical elixirs promoted their wares. Now that's open and honest.
Greatest article ever. Greatest article ever about eDiscovery.
Thank you.
Indeed. And the paragraph on this slide addresses particularly the expectation of the application of statistics to TAR when it hasn't been historically applied to keyword culling and manual review by a lot of legal professionals.
Yep.
So Maura, that last sentence speaks to one of the reasons for resisting using TAR. A lot of people have cited having to justify their approach and the idea of transparency. Is that a valid concern, and how transparent does TAR or any other AI or machine learning process need to be?
Well, I think I don't agree with that. I don't think it's correct because, well, for two reasons. One, if we could agree on a proper validation process, then process would matter a lot less, exactly how you did your TAR or whatever. And I tried to do that in the broiler chickens case, and I took hell for it. A lot of folks have rejected it, but that would certainly, if you knew what you had to do at the end, what test you needed to pass, then we don't have to argue so much about how you study and so forth. But the argument, well, I never had to do that before, just doesn't work. So consider the situation where doctors who were delivering babies weren't washing their hands. So they would go from after, I'm blanking on the word, after somebody dies, autopsy, and then they would go from an autopsy to deliver a baby and not wash their hands because nobody knew at that point that we needed to wash our hands. And once we learned that they stopped killing babies and mothers when they washed their hands, people didn't say, well, we never did it that way before. They accepted the science, and well, search is a science. And now that we know that keywords in manual review are not what people originally thought they were supposed to be, they shouldn't get a pass. I mean, everything should be validated properly, and it would be nice if we could actually agree on the proper way to compute recall and things like that. But when I tried to do that in broilers, the field wasn't ready for it.
Yeah, that's that I remember. Yeah, I remember some of the the discussion, and yeah, it is a great point about it. You'd like to know the test you're studying for. So it's really kind of, it continues to be a challenge. Very interesting. So certainly, let's go beyond TAR for a moment to other AI technologies. And here we have the Gartner Hype Cycle for legal and compliance technologies from last year. If you look at most of the technologies related to AI, things like AI governance, AI in corporate legal practice, explainable AI, and even those legal chatbots, most of them are currently either heading toward the peak of inflated expectations or down the trough of disillusionment. Expectations are tough to meet, even for an algorithm. So, Tom, we've talked about legal professionals being reluctant to embrace TAR and other AI-related technologies, but are they expecting too much of it when they do embrace it?
Yeah, I think that's probably accurate because look, if you don't understand something thoroughly, if you haven't taken the test, if you haven't prepared for the test, as Maura just said, then when you're given the tool, you just kind of, hey, it's great. It's a great tool. I just opened this new present under my Christmas tree, and look, it does everything. It's the easy search button, right?
Right.
As I think Judge Facciola said once, look. Attorneys use all these great tools like Google, and then they think that they're search experts because they found a Chinese restaurant in San Francisco on Google. Now they're search experts. So yeah, I think they do. We just, when we get it, it's like, okay, make it so.
Yeah, fair enough. And that's that whole search expertise thing is a don't get me started topic, and I'm sure for all of us, for that matter. But yeah, absolutely. And people do expect a lot from technologies, maybe more than they should sometimes. So now we get to the heart of the ethics and explainability of AI, and really into the maybe perhaps the biggest challenge associated with algorithms, which is how to avoid bias. So Maura, one of the considerations when we talk about an AI algorithm, how an AI algorithm makes decisions, is whether the algorithm and the process around it is fair or biased. What should legal professionals know to make that determination?
Well, I think the first thing to say is most, if not all, algorithms are biased by definition. They are, for two reasons. One, they're trying to discriminate between relevant or not relevant, or privileged or not privileged. So they're designed to discriminate. And number two, they're based on historical data, which they're trying to learn from and replicate. And bias isn't always bad. When we tell our GPS what direction we want to go in, that's a good bias. That's not a bad bias. So for many purposes like eDiscovery, training the tool to find what you want is not bias isn't a curse word in that context. Mm-hmm. So you really have to look at the context and determine, is this a circumstance where other values other than accuracy are important? So fairness and so forth. Because if I'm trying to predict a treatment that may actually be better for women than for men, I don't want my algorithm to be fair. I want it to tell me accurately if the algorithm is better for women than men. But when you get into, for example, the employment context, the criminal justice system, then we have to start asking questions like, are there other values that are important, like diversity? There if our data was trained only on white men, that's what it's going to predict is going to be successful. Or if there are more Black men in the prison system, then that's what's going to predict should go into the prison system. So context matters, and there are lots of places where there is bias. There's bias in the data itself. There's bias in the algorithm, often in terms of what it weights and how it weights it. There are things called proxy variables. So even if I, for example, take race out of the computation, if zip code is still a variable, zip code's highly correlated with race, it's going to bring race in. And then, of course, your human has all kinds of biases. Either they are adverse to algorithms, or they think, oh, it came from an algorithm. It must be objective, or confirmation bias, which is, I believe it, so I see it. And when we talk about looking for accuracy, we're talking about really two things: validity and reliability. Does it measure what it's supposed to measure? And does it measure consistently over time? Now, you can have a very valid and reliable tool. That doesn't mean it's fair. So we really have to ask, in what circumstances is accuracy more important to us? And in what circumstances are values such as fairness and lack of bias important to us? And it's not uniform.
Indeed, yeah, and great discussion of that, and certainly a lot of aspects to bias. So let's take a look at an example of what bias can do to an algorithm. In March 2016, Microsoft released Tay, which was an AI-powered social chatbot. Like the automated text-based chatbots that many people have encountered on e-commerce sites and in customer service conversations, Tay could answer written questions. And so they put Tay on Twitter to engage with the masses, and it was designed to engage people in dialogue through tweets or direct messages while emulating the style and slang of a teenage girl. The plan was to release Tay online, then let the bot discover patterns of language through its interactions, which she would emulate in subsequent conversations. Eventually, our programmers hoped that Tay would sound just like the internet, and sadly, maybe she did. At first, Tay engaged harmlessly with her growing number of followers with banter and lame jokes, and saying things like, humans are super cool, and why isn't National Puppy Day every day? Unfortunately, after interacting with the Twitter masses and hammered by members of a troll-laden bulletin board, Tay went on to hating feminists, denying the Holocaust, and saying Hitler was right. And all of that happened within 16 short hours before Microsoft pulled the plug.
Wow.
And that's back when Twitter was considered normal. So the warped nature of many Twitter trolls literally taught Tay to be a neo-Nazi. So that's certainly an example of what bias can do to an algorithm. So with that in mind, let's talk about bias and testing from a legal standpoint. And Maura, how do the Dalbert factors and FRE Rule 702 relate to testing and authenticating AI algorithms? And what types of questions should people ask to address those factors?
So why don't we go to the next slide first, and then we'll come back to this one.
Okay.
So this framework that I'm going to mention came from a paper called AI Artificial Intelligence as Evidence that's published in the Northwestern Journal of Technology and Intellectual Property that I wrote with Judge Grimm and Gordon Cormack, I think it was last year. And we argue that when we're looking and assessing an AI tool, we really have to force ourselves to treat it the same way that other science or junk science is treated. And we have to seriously ask a series of questions like, has this tool been tested? How is it tested? Was the testing, as a matter of fact, you can even go to the next slide if you want. Was the testing arm's length? Who did this testing? Whether the theory or the technique has been subject to peer review and publication. Does it have an error rate? What's that error rate? Is that error rate acceptable within the context which it's being used? So a 30% error rate may not be all that horrible in choosing what song I want to listen to next or what movie I want to watch, but that may be just completely unacceptable for deciding whether somebody should be released on bail or not. So we say that you can go back if you want, go back a slide. That the Dalbert factors are really, really helpful in this kind of analysis. And when we talk about experts, Federal Rule of Evidence 702 experts being used in this process, it is going to be a much more fulsome process than we're used to, because normally when you pull in an expert, it may be the person who pressed the button on the radar tool or the one who calibrated it before he turned it on or something like that. But here, the person who pressed the AI button may only know that they pressed it correctly and turned the knob where they were supposed to, but they may know absolutely nothing about how the tool was developed, what data it was trained on, how it was vetted and evaluated. So you may need actually multiple experts to come in order to show that a technology is actually valid and reliable, and it may not just be the user that's enough. We may have to go much earlier in the process to get all of the information we need for a court to make an appropriate assessment.
Right. Hey, Maura, I've got a question. Doug, could you advance a slide?
Sure.
So these questions to ask, is there anybody who does this with algorithms? Is there like an underwriter's laboratory for algorithms? Do some people submit their algorithms to anyone?
There is not at this point someone who does that. Now, if the EU artificial intelligence acts get adopted,
Yep.
there will be requirements in that particular regulation that requires you to be able to answer these kinds of questions. In Canada, when a government agency uses an AI tool, they have to do what's called a impact assessment. And they have to determine, for example, whether the tool has bias or what kinds of risks it has. And they have to make that information publicly available. But right now, no, there's not much of this out there. There are people who have just started to open consulting firms. Kathy O'Neill is one that comes to mind. She has a company called Orca, where she will come in and audit your tool for you and give you a rating on how biased it is and so forth. But that's an interesting question. If we get this proliferation of like accounting firms, but now they're algorithm auditing firms, are they going to get as captured as many of the auditing firms got, by the clients for whom they do the work?
Right. Right. Thanks.
Yeah, very interesting. And speaking of bias audits, a great leeway into our next slide, because we'll talk about a practical application of AI that affects all of us, not just legal, and that's hiring and recruiting. The use of AI algorithms in recruiting and hiring is said to provide several benefits, such as reducing the administration time and speeding up what often seems like a never-ending recruitment process. But concerns about bias have emerged here. Studies like the one hyperlinked on the slide here have found that hiring algorithms can penalize applicants for having a Black-sounding name, mentioning a woman's college, and even submitting their resume using certain file types. They can also disadvantage people who stutter or have a physical disability that limits their ability to interact with the keyboard. Now, there's at least one law that just went into effect in the biggest city in the U.S. that's requiring a bias audit before employers can use automated employment decision tools to screen job candidates. So, Mary, with that new NYC law now in effect, what impact do you think that will have on the use of AI in recruiting and hiring there and eventually elsewhere?
Well, I think it'll be similar to the impact of California's law requiring the salary ranges. All of a sudden, you're starting to see salary ranges not only for California positions, but for other positions in other areas as well. But I do think having AI audits for bias around the disparate impact on protected categories and publication of the results, that will certainly be telling. It'll help people as they're assessing where they want to apply. But I guess the sneaker issue there would be, it's not just the new AI. We've got personality tests that have been used for years that have statistics behind them. They may be swept in. And then also, can an individual opt out? And can they have reasonable accommodations? And I'm thinking from my days of, proctored certification tests, for example, certain, people with certain diagnoses may not be able to use the same testing equipment or testing methodology and may need some accommodations. And I'm thinking here in terms of video interviews and people who may not score highly on video interviews due to perhaps health reasons. So that's what I'm looking at.
Sure. Oh, those are all notable considerations. So question from the audience: how do you make sure the bias audits aren't biased? Any thoughts, Maura, anybody on that? What do you do to make sure that the bias audit is fair?
Well, for example, one of the things that I've learned to do when I do hiring now is we come up with a standard list of questions in advance that are asked to every single candidate so that they're being assessed along the same criteria. I think one way would be to sort of specify what goes into and what has to be looked at in terms of an AI audit. So at least if there's a standardized process, it can be followed. I think the biggest risk is the one that I mentioned before, which is the same way that your accountant really doesn't want to come back and have to tell you, you accounted for something incorrectly, or you've got a tax problem, whatever. If people want to get additional business, are they going to, let people off gently? Or what happens if you don't get the results you want? Do you go just get another audit from another person? There's always these challenges, but maybe at least having some standardized process might help a little bit.
Yeah, certainly seems to make sense. So let's turn to something now with even higher stakes, criminal law and access to justice. There's an algorithm called Compass that's been used in several states, including New York, Wisconsin, California, and Florida for several years now as part of the criminal justice process. So, Maura, what is Compass? What was it originally designed for? And what are some of the bias concerns that have emerged about it?
Okay, so Compass is what's called a risk assessment tool. So it was originally designed after somebody committed a crime, and before they had their visit to court and the decision was made about bail or released on their own recognizance or whatever, they would be given this 137 question test to help determine what treatment needs the person needed in order to A, not commit another crime, and B, not land back in jail. And the issue was that this is a classic example of function creep, where it was designed solely to determine treatment needs. It became used for sentencing and bail decisions, particularly the sentencing, which is a completely different use, without the proper validation. And if you look at some of the questions the tool asks, well, first, your home address. Zip code's highly correlated with race. It asks, was one of your parents ever sent to jail or prison? Well, we know people of color are far more often in our prison system, so that's going to be correlated with race. And there are a number of other questions that are highly correlated with socioeconomic status, etc. So even though it never asks the race question, it brings it in. And so you may ask, well, what kind of problems did this cause? Well, ProPublica did a study looking at Brescia Borden, who had stolen from a yard a scooter worth about $85, and she was administered the Compass tool, and she scored as high risk for committing another crime. And Vernon Prater, who had stolen about an $85 tool from like Home Depot, scored a 3. And when you went and looked at their actual risk based on their history, Brescia had, some truancy and stuff like that. But Vernon Prater had armed robberies and had already done a stint in jail. And you start to ask, well, how does that tool get it so wrong? And while Compass was about 61% accurate in predicting recidivism for everybody overall, when you looked at compared false positives and false negatives, in other words, errors where it says somebody is going to repeat a crime and they didn't, like Brescia, versus false negatives where it says the person can go free and they shouldn't because they're going to commit another crime, like Vernon, they found that when the Compass said somebody was likely to recidivate or commit another crime, twice as often that person was a Black person. And when it said somebody who really was high risk, was low risk, and was unlikely to commit a crime, twice as often that was a white person. So even though under the overall accuracy seemed to be the same for both races, when you looked at false positives versus false negatives, they were differentially distributed by race. And that had a lot to do with a lot of these questions bringing in race through proxy variables. And so if you don't do your proper testing and validation and ask these questions and look for the bias based on race, age, ability, gender, sexual orientation, and all of that, it can very easily creep in even when you're trying to use something for the best possible purpose.
Yeah, indeed. Excellent walkthrough of that, and certainly very eye-opening. I remember covering a case involving Compass a few years ago, the Loomis case, and so yeah, it's been around for a few years, and obviously some articles about it have pointed out some of the concerns. So another area is facial recognition, which is another example of the use of AI algorithms in criminal law. And I wrote about the top case for EDRM's blog last year, where a defendant was accused of an armed robbery in New Jersey, even though he claimed he was dozens of miles away from the crime scene when it happened. New Jersey police found that witnesses at the scene couldn't describe the perpetrator, and a facial recognition search run in by New Jersey's Regional Operations Intelligence Center turned up no results. But then they turned it over to the NYPD, and the NYPD's facial recognition algorithm tagged him as the suspect. His lawyers requested detailed discovery on the facial recognition systems used by the NYPD to identify him, the original photo, and any hits performed by the NYPD before a search was run, as well as information on the analyst who performed the search that I identified him. But the court rejected that request. So his lawyers appealed, and they were supported by an amicus brief filed by the Electronic Privacy Information Center, the Electronic Frontier Foundation, and the National Association of Criminal Defense Lawyers. And one key argument in the amicus brief is regarding the low quality of the image and the fact that the subject's face is turned away from the camera, which the rights groups pointed out raised the risk of misidentification. They also cited the fact that the failure to return matches in New Jersey suggests that Mr. Ortega is not the subject of the probe photo and thereby innocent, or that the quality of image was of too low quality to ever obtain reliable results. No word yet on whether that appeal was successful, and we'll discuss the second case in more detail in a moment. But it's a similar situation where, again, the defense sought to examine and test the AI algorithm called AccuMatch, but the court in that case rejected the request as well. So, Tom, why do you think courts are rejecting an investigation of facial recognition technology? Wouldn't such a review up front save time downstream during the appellate process?
Yeah, but courts are reluctant, judges are reluctant to make technical decisions. It's nothing new to just facial recognition software. Again, our old friend Judge Fasciola, in his famous quote about going where angels fear to tread, to have a judge make a technical decision. They're reluctant to do that. And when it comes to technology in the court and these sorts of issues, heck, we're still arguing about lie detector tests and their accuracy and admissibility, and that was invented in 1921. So, I just think it's an area where judges are very, very reluctant to get involved, and they'd like to see, as we just discussed a minute ago, some sort of standards or independent testing that talks about it. Facial recognition also has, some real horror stories. We had one from right down the road here, an arrest warrant in Baton Rouge fired up some facial recognition software where a person in Atlanta was arrested and spent 6 days in jail, and it turned out he'd never even been in the state of Louisiana. And more importantly, when the attorneys were arguing about it, they said, look at the picture. he has a large, prominent mole on his face, and the picture that the facial recognition brought back did not. So, there's some real questions about how well these things work.
Sure, and obviously one of the arguments is the trade secret aspect of the technology, and companies not wanting to divulge information because they're trying to protect trade secrets. So that's also
Right.
a battle part of it.
And I think further, law enforcement agencies are rightfully reluctant to disclose a lot of the technical underpinnings of what they're doing. The real problem is this area is becoming really widespread. The Georgetown Law Center for Privacy and Technology, in a recent article, said that they thought that at least half of the adult population in the United States had their picture in a police facial recognition software program somewhere. And everybody was shocked at that. And I thought to myself, well, you got your picture on your driver's license, don't you? If you get a driver's license, you're probably in a police facial recognition software program in your home state. So it doesn't seem that surprising to me. So it's easy to use. It's something that's out there. I don't think these problems are going away anytime fast.
Yeah, no, I agree, and that doesn't surprise me either. So, so the Warner case from the previous slide was discussed in the guide, the link that you see there below. And Maura, you were one of the authors of that guide, from which the factors were taken for this slide. So, could you discuss them and how applying the federal rules of evidence relates to authenticating AI for facial recognition?
Sure. So we use this as a hypothetical in that particular article on trustworthiness of AI. And again, we go back to where can bias come into the process? And it can come in the data, it can come in the algorithm, it can come in the human. So how does it come in to the data? Well, different kinds of photos are taken under different circumstances. So photos taken in a lineup are very different from photos that are taken on social media. And depending on how you've created your photo database, where you have gotten those photos from, it can very much impact the quality of the matches that are going to occur. Because we don't know what the algorithm is going to pick up on. It may pick up on similar lighting or the same angle rather than the actual similarity of the face. We also know that the software itself varies. There are very solid studies that show that facial recognition software is best on white men and worst on Black women, and then sort of varies in between. And we need to know some of the error rates. Now, we know that, for example, the National Institute of Standards and Technology has done some measurement in this area, but if this is being used in a court case, has this tool been one of the ones that have been tested? What's the error rate? Who's it being used on? And then finally, the person making the matches has biases. And I recently read an article that I now teach in one of my courses. It turns out that when white people look at white faces, they look more different from each other than when a white person looks at, for example, Black faces or Chinese faces. So to the degree that there is a similarity between the person looking at the pictures and the race of the actual picture, if it's the same, we make much more differentiated distinctions than we're able to do when we are looking cross-race. And so all of these things come into play when we're using this facial recognition technology. So if you want to move to the next slide, we have to be using our rules of evidence properly. So we have to, normally the court is the gatekeeper, and if it's more likely than not to be what it purports to be, they let it in. But in these areas where, like facial recognition, where somebody's being arrested or convicted, I think we really need to have a higher standard for what we admit, and we ought to use Federal Rule of Evidence 403, that the prejudice outweighs the likely benefit when the tools are not valid and reliable, and haven't been shown to be valid and reliable. And as far as the authenticity rules, then again, it goes back to what I said earlier, that it can't just be some very global affirmation or certification. We really need our experts to get into much more detail than they've done in the past. And we walk through all of this, not only in that article, but in the Northwestern article in great detail.
All right. Well, great. That's, yeah. I had not really thought about the consideration of assessing different races differently like that, but certainly makes sense. So very interesting. One more thing on the criminal side, and it's kind of good news, bad news. The good news is that there's legislation out there designed to open the black box of forensic algorithms that would prohibit the use of trade secrets privileges, direct NIST to establish computational forensic algorithm testing standards and a computational forensic algorithm testing program, and require federal law enforcement to comply with standards and testing requirements in the use of forensic algorithms. The bad news, unfortunately, it hasn't advanced past the introduced state some 21 months after being introduced. So, Tom, you gave me the hat tip on this legislation, but as I just mentioned, it hasn't advanced past the introduced stage. So do you think we'll see any federal legislation that applies standards to forensic algorithms anytime soon?
Not in this session of Congress.
No, fair point.
But never say never. I mean,
Sure.
The people who've been introducing the legislation have been persistent. I don't know what their election status is, whether they were reelected or not to Congress. But,
Sure.
It's an idea that isn't going to go away. So it'll keep coming up.
Right. Well, there's at least that, and there's hope on that. So that's a good point in that regard. Of course, algorithms need data to run, and they need lots of data. And the more data they need, the more likely some of it's going to be your data. And data privacy laws like GDPR and CCPA require user consent to use that data. And that use is supposed to be restricted to the stated purpose for which consent was given. But there's claims out there that many of the apps are using the data for other purposes. So certainly there's a link to the article on the slide that gets into some of those ethical issues of internet privacy. And there's a link to a resource, the Organization for Economic Cooperation and Development, which actually has a live repository of over 800 AI policy initiatives from 69 countries, territories, and the EU, along with several other useful resources. And hat tip to Rob Robinson for the heads up on that resource. So, Mary, obviously, we're getting toward the end here. We could spend an entire webinar just on this discussion and privacy concerns about AI. So how do you see this impacting legal professionals in the next few years?
Well, I think as Tom and Maura were talking about facial recognition, machine learning and AI intersecting with biometrics, that is rapidly evolving, and that's going to impact access. Can you get into a system? And so that will be important in many legal cases and has extreme privacy impacts. Also, machine learning and AI, to the extent that they're trained on data sets with personal data that's not pseudonymized, that can expose the data if it's not remediated prior to training. There's more advanced, the chips are getting better, the computational speed's getting better, quantum computing is coming up. So a lot of things can be, for lack of a better word, reverse engineered. And then as legal professionals, I think we need to understand that these algorithms are creating what legal professionals and governmental professionals and citizens used to craft. And that's the structures of how society and individuals interact in family, employment, military, justice, commerce, many, many different aspects. So it's a very, very important topic, Doug.
Indeed, and I wish we had more time to cover it, as we're getting almost to the top of the hour here. So let me get through these last couple of sections really quickly. If I can get my button to move, there we go. Certainly, from a standpoint of what AI expects from its lawyers regarding the consideration of AI, certainly the use of AI impacts several duties and responsibilities of lawyers, including competence in Rule 1.1, which of course includes Comment 8's requirement to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. And that model rule and several others are linked to within this slide. And they're also referenced in ABA Resolution 112, which was published over 3 years ago. And you can see the entire resolution there. I won't read it, but it is notable that the ABA has some guidelines with regards to how to address the emerging ethical and legal issues related to the use of AI, including several of the things we've been discussing this entire time. So with that, everything we've talked about, that begs the question, how do you know what to look for in an AI solution? So with all the considerations we've discussed, what questions should audience members ask vendors about their AI products to make informed selections about AI technologies?
Sure. So you really do have to get past the kind of sales guy and really ask detailed questions, like starting with, what do you mean when you say your tool uses AI or uses machine learning? Because I've heard lots of people call things AI that I wouldn't consider AI, like, deduplication or something like that. How much do we have to clean our data for it to be used by your software? Not everything works off the shelf on all kinds of data. And if you're going to have to do massive processing or cleansing to be able to use the product, you ought to know that. What amount of data and training do we need to use your software effectively? Virtually none of the off-the-shelf tools just work automatically, I'll say. I mean, they're going to need some training on your unique data, and you need to know whether it's a lot or a little. And next one is, what algorithms and assumptions does your software rely on? So that gets into some of the questions about bias in terms of are there things sort of hidden underneath that I need to know about that impact the tool or decisions that have been made? What resources will we need to implement your software successfully? If it's going to take 11 months to get it set up, you ought to know that if you're going to have to hire an extra consultant and so forth. What tools do we need to interpret the model and to visualize it? Are they included? Some tools just do the actual number crunching, but they won't help you, do any of the presentation stuff that you may need, the graphs and so forth. So you need to know if there are plugins or add-ons. And probably the most important tool is, has your tool been validated? And if so, who did the validation, under what circumstances, and so on and so forth. All those questions we've been talking about all day today. You want to know what evidence there is that tool works.
Yeah, absolutely. And there's the link to an article that Maura wrote with Reese Morrison that gets into more depth on these questions. So certainly check that out. So we are 3 minutes past. We do have a couple of questions I'm going to try to get to pretty quickly. The first one, and I think I know the answer to this, and I'll just kind of cut to the chase back to when we were talking about the eDiscovery Medicine Show article from 2021. So Maura, has anyone, including any eDiscovery vendor, published a rebuttal to that article?
Not that I'm aware of. And tons of people have reached out to me including from people who sell eDiscovery software and services, and said, we agree with you 110%, but we wouldn't say that publicly.
Indeed. Yes. And then another question is, what are the panel's thoughts on portable models to train TAR algorithms?
I'm a skeptic. I haven't seen the validity and reliability shown. I haven't seen the studies. There's nothing peer reviewed that has convinced me. I mean, set aside, Mary could probably talk forever on the privacy implications of taking one client's data to use to train a model for another client. But I would say beware. And I think if you're using it for your own client, you're doing 6 matters for them, and the same outside counsel have done work for that client, then maybe you can build a privilege model that will work from data set to data set because it's the same lawyers and stuff like that. But across matters, taking fraud model A and applying it to a completely different client's data on fraud, I'm skeptical. I just haven't seen the proof yet.
Okay. All right. Very good. All right. Well, I want to thank everybody for attending today. Thanks to Mary, Tom, and Maura for their excellent insights. This was a fun discussion, and I will turn it back over to you, Mary, to close us out.
Well, thanks very much, Doug. And don't forget your resources, the paperclip on the side of your console. You can learn more about each of our presenters, and there's a link to register for tomorrow's webinar on whether humans are underrated in eDiscovery. So sort of the flip side of all of this. And at the end of the webinar, you can download a certificate of attendance from your BrightTalk account feed. So we thank you, Doug, for anchoring. Thank you, Tom O'Connor, Dr. Maura R. Grossman for this wonderfully insightful presentation. And our thanks to the EDRM community for your kind attention. Thank you.
Thanks,
Thanks, everyone.